डॉक्टर बाबासाहेब आंबेडकर ओपन युनिव्हर्सिटी.
Namaskar and good evening, friends. Friends, I'm Dr. Dhaval Pandya. Welcomes you all from the Chaitanya studio of Dr. Babasaheb Ambedkar Open University. Today, we are going to learn about business law. A code of business law is MBA01C106, unit number 2, Indian Contract Act 1872, part 2. What we learned in previous lecture, we'll go through it and we'll continue with this. Okay, in previous lecture, we learned about special contracts, contracts, indemnity and guarantee, contract bailment. In today's lecture, we'll learn about special contracts, contracts pledge, and contracts of agency. Contracts of pledge. In pledge, the bailer is in this case called the pledger or pawner, and the bail is called the pledgee or pawnee. Section 172. A pledge is a bailment of for security. It is a special kind of bailment. Pledge by non-owners. Ordinarily, only a person who is in the real owner of the goods can make a valid pledge. But in the following few cases, pledge made by non-owner will be also be valid. First, pledge by a mercantile agent, section 178. Section 178, where a mercantile agent is, with the consent of owner, a possession of goods or the documentation of title of goods, any pledge made by him were acting in the ordinary course of business of a mercantile agent shall be as void as if he was expressly authorized by the owner of the goods to make the same, provided that the pawnee act in good faith and has not at the time of the pledge notice that the pawner has no authority to pledge. Second, pledge by person in possession under voidable contract, section 178 Act. When a pawner has obtained possession of the goods pledged by him under a contract voidable under section 19 or section 19A, but the contract has not been restrained at the time of the pledge, the pawnee acquired a good title to the goods, provided he act in good faith and without notice of the pawner's defect of title. Third, pledge where pawner has only a limited interest, section 178. Where a person pledged goods in which he had only a limited interest, the pledge is valid to the extent of the interest. Fourth, pledge by co-owner in possession. If there are several joint owners of the goods and goods are in the sole possession of one of the co-owner with the consent of other co-owners, such a co-owner can make a valid pledge of goods. Fifth, pledge by seller or by buyer in possession after sale. A seller who has got possession of goods even after sale can make a valid pledge, provided the pawnee act is good in faith. Rights and duties of pawner and pawnee. The rights and the duties of pawner and pawnee are almost similar to those of bailer and bailee, but the right of the pawnee and pawner need a special mention. Right of pawnee. Right of retainer. Right of retainer. First, the pawnee may retain the goods pledged until his dues are paid. He may retain them not only for the payment of the debt or the performance of the promise, but for A. the interest due on the debt, and B. all necessary expenses incurred by him in respect of the possession or for the prevention of the goods pledge, section 173. He can, however, exercise only a particular line over the goods. 2. Second, right of retainer for subsequent advances. When the pawnee leads money to the same pawner after the debt of the pledge, it is presumed that the right of retainer over the pledge goods extended to subsequent advances also. This presumption can be rebutted only by a contract to the contrary, section 174. Third, right of extraordinary expenses. The pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged, section 175. For such expenses, he has no right to retain the goods. He can only sue to recover him. Fourth, right against true owner. When the pawner's title is defective. When the pawner has obtained possession of the goods pledged by him under the voidable contract, like by fraud, undue influence, coercion, etc. But the contract has not been reclaimed at the time of the pledge, the pawnee acquires a good title to the goods provided the act in good faith and without notice of the pawner's defect of title, section 178A. Fifth, pawner's right where pawner makes default. Pawnee's right where pawner makes defect, section 176. Where the pawner fails to redeem his pledge, the pawnee can exercise the few rights, like he may file a suit against the pawner upon the debt or promises and may retain the goods pledged as a collateral security. Second, he may sell the goods pledged after giving the pawner a reasonable notice of the sale. Of these two rights, where the right of retain of sell the pawner goods are not concurred, the right to sue and sell the concurred rights. C. He can recover from the pawner and deficiency arising on the sale of the goods by him, but he shall have to hand over the surplus, if any, realized on the sale of the goods to the pawner. Now, rights of the pawner. There are four rights. Rights to get back goods on the performance of the promise or repayment of loan and interest, if any, the pawner is entitled to get back the goods pledged. Second, right to redeem debt. Quite often a time is stipulated for the payment of the debt or performance of the promise for which the pledge is made. In such a case, if the pawner makes default in payment of the debt or performance of the promise at the stipulated time, he may still redeem the goods pledged at any subsequent time before the actual sale of them, but he must in this case pay in addition any expenses which have arise from his default, section 177. Third, preservation and maintenance of the goods. The pawner has the right to see that the pawnee, like bailey, preserves the right, pledge, and properly maintain them. Fourth, right of an ordinary debtor. The pawner has, in addition to the above right, the right of the ordinary debtor, which are conferred on his by various statute status means for the protection of debtor. Now, contract of agency. When a person employs another person to do any act for himself or to represent him in dealing with third person, it is called a contract of agency. The person who is so represented is called the principal, and the representative so employed is called the agent, section 182. The duty of the agent is to enter into legal relations on behalf of the principal by third parties, but by doing so he himself does not become a party to the contract. Not does he incurs any liability under that particular contract. Principal shall be responsible for all the acts of his agent, provided they are not outside the scope of his authority. Definition of agent. One who agrees and is authorized to act on behalf of another, a principal to legally bind an individual in a particular business transaction. Third parties pursuant to an agency relationship. This is definition is given by West Encyclopedia of American Law. Now the second is Durham's Law Dictionary. What it says: a person who has received the power to act on behalf of the another, binding that another person as if he or she were themselves making the decision. Durham's Law Dictionary. A party that has expressed oral or written or implied authority to act for the principal, so as to bring the principal into contractual relationship with other parties. An agent is under the contract is obliged to the principal, and when acting within the scope of authority delegate by the principal, bind the principal within his or her acts. Additional powers are assigned to agent under the legal concept of apparent authority. Now, definition of principal. In commercial law, a principal is a person, legal or natural, that authorize an agent to act to create one or more legal relationship with a third party. In an agency relationship, the principal is the person who gives authority to another, called an agent, to act on his or her behalf. Now, essential of relationship. Friends, here we conclude today's lecture. We'll continue with this in next session. Till then, goodbye and take care. Thank you.